opening this plenary session, and let me welcome you all, because now everyone who's at the conference is in this room right now, so give yourself a round of applause because you're going to be in the live album. And I think I'm about to give my last speech of the weekend, and I can't tell you how happy I am. So this is the last time you'll have to put up with me, unless Curtis changes the program on me, which he does on a regular basis, but nonetheless. We're going to be talking about climate change today. What's so funny? We're going to be talking about climate change. Let me tell you why. Let me ask you a question first. How many of you here in this room believe the climate change is happening as we speak? Because I have a room of very, very well-educated and informed people. You all believe that what we used to call global warming is no longer just a concept, that it's something that it's happening. If you're not sure, ask the people from Florida. And I hope nothing happens to anybody down there. I have a lot of friends who don't believe in climate change. And we have very heated discussions about it. And I tell them, most of the educated people in the world, 95% plus of the scientific community, believe that climate change is real. What makes you think you're right and they're wrong? And they're pretty adamant about it. So rather than arguing with them, I've changed my attitude with them. I said, look, let me turn the tables on you. Let's say that 95% of the scientific community does not believe in climate change. That most of the educated world does not believe in climate change. Only 5% of the world believes in climate change. If that 5% happen to be correct, what are the consequences? Would it not be catastrophic? Would it not be the end of civilization as we know it? Usually when I paint it that way, they say, well, at least we could look into it. We could devote some resources into it. You're all with me so far? I want you to exchange the words climate change and put VRI in the example I just gave you. If there's only a 5% chance of VRI being properly deployed, what happens to your profession? We'll talk about that during the plenary. This is for the people who say, well, we don't know and what could happen. You know, there's too much at risk. There's too much in play for us. It could completely obliterate our profession. I hope it never happens. But let me ask you something. If we are 1,000 members whose lives depend on interpreting, how much resources do we have to devote to VRI? $100? $1,000? $10,000? $100,000? I don't know where that money, I don't know exactly what that figure is, but I am the president of CFI, and I have to make sure that all of you have a job next week. And it would be highly irresponsible of me not to devote resources to the study of VRI. So I have to tell you, in spite of the controversy, in spite of everything that's been said about me and about this topic, I'm not saying that the sky is falling. I'm saying it's getting overcast out there. And we need to keep a vigilant eye on what's going on with VRI. To that extent, it's not that I went to Paris to visit the Eiffel Tower. I went to the VRI conference. I visited Florida. We visited Fresno. We're going to go to Arizona soon. We've been all over the state. We think the VRI is here, and we are very, very concerned about it. So we went and looked for the world's leading experts in VRI, and we're very, very lucky to have someone like Camille, Taiara, who's sitting right next to me, who used to be a reporter and now is an interpreter, who's done amazing investigative work on VRI. Next to her, we have Janet Hudec, who used to be a board member and has done the bulk of the foundation of the VRI research. I asked last year, Janet, can you send me your file on VRI? She sent me a gigabyte of information, okay? a gigabyte. All right? Next to her, we have Cynthia Giambruno, who is a professor in Spain, and she's here visiting. She is part of the Avidica study. She's actually an Arizonian, so welcome home. Sort of. The West Coast, huh? Close enough. Yeah. And next to her, we have Sabine Braun, who teaches in England. She's originally from Germany. Sabine, welcome also. Another one of the world's leading experts on VRI. Next to her, I just met her, so I know as much about her as you do personally, except that I've read her work. She's fantastic. She's a professor at UCLA. Professor Eagly, welcome. And at the end of the table, I don't know what her name is, but I don't, she keeps on showing up at these meetings. I don't know why. That's Aranguren at the end, who's our legislative director. So, I don't want you to panic. I'm not panicking, but it's something. Thank you, Agustin. But it's something that we need to look into it. And I hope when all is said and done, VRI becomes, I don't know, like the 8-tracks. You know, the cassette tapes. My son, my 14-year-old son, saw a cassette tape deal and says, "Dad, what's that?" He'd never seen a cassette tape. I hope one day we say the same thing about VRI. But just in case that doesn't happen, I'm glad that you're all here. So this is the plenary session on VRI. Enjoy. Camille.
Thank you, Ariel. Well, so like Ariel said, my name is Camille Taiara, and I am the chair of CFI's Language Access Research and Advocacy Committee. As such, I've been doing some research for CFI on VRI. And I want to welcome you all to this plenary, VRI in judicial settings. As you all probably know, California is planning on implementing some form of VRI, probably for courtroom proceedings. Janet will talk to us a little bit about that. This plenary really presents a special opportunity, though, for us to hear from some of the world's experts on the use of video remote interpreting in judicial settings. And it may very well be the first forum in the United States that begins to take a serious look at VRI's impacts on language access and on due process. I want to encourage dialogue during this. We don't have much time given that we have 5 panelists and all of you, but we have some monitors on the various corners of the room. If the monitors can stand up and kind of wave, they are going to be handing out index cards. And we really encourage people to write down your questions on the index cards, give them back to the monitors. After the presentations, we will take some of those questions, read them, and to the panelists, have them answer. And if time permits, then we can also take some more questions from the floor to encourage further dialogue. So again, Nariel pretty much introduced our all-star cast, but I did want to say just a teeny bit more about each one of them. Janet Hudec was on the Joint Working Group for California's Language Access Plan and currently serves on the Language Access Plan Implementation Task Force. She comes to us from Madera, California, the Superior Court there. Sabine Braun is Director of Translation Studies at the University of Surrey, where she teaches and supervises PhD students in interpreting, applied linguistics, and intersemiotic translation. She was the leader of the Avidicus project, which is probably the only project in the world that has done serious study from an academic and empirical perspective on the impacts of VRI. And she's done a lot of research on the integration of video conferencing, interpreting, in legal settings. With her is Cynthia Giambruno, also an important member of the Avidicus project. For a good decade, Cynthia has also been doing research on the topics, on this topic across Europe, and advocacy as well. And she teaches interpreting at the University of Alicante. And then we have Professor Ingrid Eagly. She teaches law at UCLA. She has expertise in the treatment of non-citizens and the U.S. justice system, the use of technology in the courtroom, among other things, and most recently published findings of a very interesting study about the effects of video conferenced hearings in immigration court that came out in the Northwestern Law Review. And then finally, we have our own Mary Lou, our legislative director and bargaining coordinator. So I'm going to go ahead and turn it over to Janet. Thank you all for being here.
I do, there we go. I'm a much better speaker when I stand up. So I tend to move around, so bear with me. So I'm Janet Hudec. I am part of, I'm a Region 3 interpreter. I work in Madera Superior Court. I'm certified, of course. And I've been working there for quite some time. I'm also been appointed to CEAP, which is the Court Interpreter Advisory Panel, which back in 2003 was actually joined forces with other committees in Judicial Council to form the joint working group, which created the Language Access Plan. Now, how many of you here, just by a show of hands, have actually looked at the Language Access Plan? Okay. Well, it's online. You can get it at the Judicial Council. I really encourage everybody here to actually become familiar with it. Just take a little glance. It's a series of recommendations that the state's going to be implementing and will be in probably full implementation by the year 2020. I think it's very important that we all actually take a look and see what's going on there. But now the Language Access Plan has been it's done, it's created, it's been in, we're starting to implement it. We finished the process of action and it got approved last year in 2015. So now we're part of the, and I was appointed to be part of the Language Access Implementation Task Force. And our job basically is to oversee that these recommendations are actually going and moving forward and being implemented throughout the whole state. So part of the Language Access Implementation Task Force, from now on, I'm just going to call it the Task Force because it's a mouthful. But part of the Task Force is that, or what we do at the Task Force is implementing all these recommendations. It's a big task, and then they're divided in different sections. So what they did is that they kind of separated us in different groups. And from the beginning, from the time that I was part of the joint working group, I was assigned to the Technology Solution Group. So that's where I belong. CEAP also has their own Technology Solutions Committee. But here on just for the purpose of the meeting, I'm just going to concentrate on what we're doing with the task force. In the task force, the Technology Solutions Subcommittee, what we do is we find technological solutions to either create or improve already systems that are already in place to improve language access. And part of that is VRI. In fact, a lot of the conversation that happens, I would say a good 95% of the conversations that we have and the discussions that we have in this task force, in this subcommittee, is about VRI. And VRI is being implemented. In fact, we've already done a request for information. There's been people that submitted, and there's been demonstrations done, and 3 courts have been chosen to actually implement this pilot program. And this pilot program is going to start the beginning of next year. In fact, it will start actually on the 1st. Those courts are in Region 3, well, actually 2 of them, except for 1, and that is Sacramento, Merced, and Ventura County. So these are the pilot courts. And there's, like I said, there's already been a request for information. There's been vendors. We're moving along and actually seeing what they have and actually trying to kind of choose some of the vendors that are going to be participating in this VRI. So that's what's really going on. Now, the technology solutions, like I said a few minutes ago, it's not just about VRI, although most of the conversation, I would say, in my opinion, about 95% does revolve about VRI. But we're also about finding other technological solutions, like improving a way to tag cases and so forth. So let me just say that part of the LAP, it says that in-person interpreters or in-person interpreting is preferred. However, in my opinion, VRI and this pilot that we're going to implement, to me it seems like it's kind of contradicting itself. Because some of the ideas of this VRI, and I'm going to take Spanish for example, is that they're trying to do VRI with interpreters that are already in the building. And to me, that kind of defeats the purpose, because the purpose of VRI is VRI was supposed to be implemented and used when you cannot find an interpreter, when they've gone through all the resources in trying to look for an interpreter, and there's none. And this is something that we need to get it done today for whatever reason, and put it out or do whatever we need to do to get an in-person interpreter, because in-person interpreter is preferred over VRI, and I'm pretty sure after everybody else speaks, you kind of know why. And with this pilot program that's happening, if the interpreters are there and they're being interpreting in a different room in the same courthouse, how is this in-person interpreting kind of happening? So to me, in my opinion, it kind of contradicts itself. So I'm just going to leave it at there, because I'm pretty sure a lot of people are going to have a lot of questions, and this is a big topic to talk about just in a few minutes. Thank you very much.
So next are our Leviticus researchers, Cynthia and Sabine, and they're going to talk.
There's a microphone right here, Camille.
Cynthia and Sabine are going to talk a little bit about some of the research that they've done, the findings around the implications of VRI in judicial settings, how it impacts interpretation, communicational dynamics, what can be done to mediate it, and what the limits are.
Okay, thank you. Well, first of all, thank you very much for inviting us to come here and to share what we have found with you. We have working on projects that were funded by the European Commission on VRI since 2008. I would like to go quickly sort of back a little bit to that time. In Europe at that time, in 2007, when we prepared these projects, the situation clearly was that the justice sector had already turned to using video conferencing in courtrooms and in the legal system to address as a potential solution to address a whole lot of different types of problems with security of transport of prisoners, problems with costs, problems with the speed of trials. So there were lots of issues, but what was very little studied at that time was the impact of combining this technological mediation of the communication through video links with linguistic and cultural mediation through interpreting. So this combination of video conferencing and interpreting was a big unknown, but at the same time the legal sector was interested in implementing solutions for that as well. And that's, I think, the point where our research ideas started. We noticed that there is a problem, so the research we set up had several parts, and I think we were lucky that we were able to obtain funding for this since 2008 until now. The European Commission has supported this exploration. So we started by surveying legal stakeholders and interpreters about, well, first of all, things like their own attitudes towards the whole issue of VRI, their at that time existing experience, however limited, with VRI. We also wanted to find out more about the different settings where video conferencing and interpreting come together. and also the settings that are in planning, so that we could decide where we would start exploring in more depth. One of the scenarios that, of course, arose from that was the kind of VRI that you are talking about here currently in California. To give you one example, at the time when we started this, the Metropolitan Police in London was about to implement remote interpreting, whereby interpreters would be placed in a hub with several workstations and would be linked to police custody suites to interpret remotely in police interviews. So that was the concrete case that was on the cards when we started this research. And there were, of course, other settings as well. There were court hearings that included remote defendants in prison, that included remote witnesses, and for which an interpreter was somehow needed to be integrated in these hearings. So there was a whole range of these settings. And from our surveys, we found that there was a disjoint between what the legal stakeholders had to say. For example, what they had to say on the reasons why they want to use video conferencing. It was always a large variety of reasons. It was never just money. In fact, money was often mentioned, ranked rather low. It was other concerns, like I mentioned before, security or simply speed and things like that. Whereas when we asked the interpreters, why do you think VRI is used or video conferencing is used in court? Often the first answer was, well, it seems to be a money-saving exercise. The argument is always just money. Get on with it. Don't ask any questions. So there were, in the attitudes and in the perceptions, there were big discrepancies. At the same time, when we asked the interpreters then, what is your perception when you actually do video link interpreting? What is your perception of your own performance in this? Do you think you can perform as well? The answers that we got were surprising. The interpreters often, or the majority of interpreters told us, well, I have often difficulty understanding properly what is said in a video link. I also find it difficult to create a rapport, a relationship with the people who are in this video link. But when it comes to their own output, their interpreting performance, the interpreters generally thought that there isn't that much difference between what they do in VRI and what they do in on-site interpreting. We also have quotes from people who then said, I think there is very little difference. The only thing, for example, one of our informants said, the only thing that can really go wrong with the video is the sound. And then because you don't hear well, you really don't really know whether you hear the person properly, there can be an interference. Or another person said, well, in principle, I think there is no difference. I would just say it's a little bit more tiring. Then another person went on to say, yeah, well, it's a bit more tiring. And when you get this fatigue, then your concentration is affected. And then your interpretation is affected. And then your accuracy is different. So from these informal and anecdotal reports, what we gathered is there seems to be the perception it is okay to do, but when you start digging deeper, you find there is no difference, but, and then comes a but, and then comes fatigue, then comes I can't hear properly, then comes my concentration is affected, and so. So what we then did, we set up a comparative study between on-site interpreting and video remote interpreting. We chose investigative interviews, so which is, we have to be clear, quite different to what you are looking at here at the moment in courts. We had several reasons for doing that. Well, partially also because it's a very small group setting, and we thought we look at this, and if it doesn't work there, then chances are it doesn't work in larger settings like in a courtroom, of course. And what we also did is our first focus was on the quality of the interpreting performance. We really wanted to see whether these comments that we got, how much truth there is in it, whether these perceptions are actually accurate. So we try to control all variables. We set up a range of simulations, a set of simulations where the same group of interpreters worked in on-site interpreting and remote interpreting, all simulated, but with real interpreters, real police officers, in our case, for example. And sorry. So in a nutshell, what we want, and you have to take my word for it, there is no time here to sort of elaborate on all the findings. We compared this really by looking at a number of interpreting categories like accuracy, completeness of the interpretation, are there any omissions? So the way you would normally look at legal interpreting, and when we use statistics, that's the way we can deal with this in science, we actually found in our sample, for this particular instance, significant differences in the interpreting quality between VRI being a lot lower than the interpreting quality that people produced in on-site interpreting. And that concerned accuracy issues, that concerned omissions, that concerned distortions, that concerned terminological problems, so a whole lot of things that you don't want to have in legal interpreting. We then also found tendencies of interpreting problems to co-occur. For example, we often found that turn-taking problems, I mean, a police interview being, of course, a very interactive setting, yeah? So where you take turns all the time, and whenever turn-taking coincides with a slight overlap in speech, there was a tendency that information got lost, for example, and the interpreters were not always aware that this got lost because they had no way of hearing properly. We certainly see from the way in which the problems that we found are distributed across our police interviews, fairly simple half-an-hour interviews, that you can conclude from this that there is an earlier onset in fatigue in the VRI, because we can see that about 2/3 through our interviews, the number of problems actually rises in VRI, and it starts to behave differently than in the face-to-face condition. And so after looking at these things in our first study, we replicated the study. We looked at whether a short training, whether the use of better technology, whether the changes in the way screens, cameras, and all that was positioned, whether that had an impact on that performance. In short, because I've only got 1 minute left, there were some improvements, but it didn't change dramatically. There was no magic in this. So we still basically find that the outcomes are quite complex. We basically find that although over time the confidence of the interpreters in doing this increased with a little bit of training, with more discussion around this, there was performance improvement in some areas through the changes in the variables that we made, but there were still problem areas. So we still saw that all the problems that we know from interpreting, linguistic problems, accuracy, communication, dynamics, that was still problematic. It changed, and of course there was the fatigue, the cognitive dimension. So we can't really say with confidence here that there is no difference. But we have to be careful in drawing and in sort of the conclusions that we draw from this. For me at the moment, I must say there are more questions about this than answers, because our study was a very small sample. So the questions that Cynthia is going to address now also is really which problems, we have to ask ourselves which problems can be resolved through things like training, to technological improvements, which of those are likely to prevail, and more generally, how can we go about potentially mitigating the problems that we found? What is the contribution of maybe training, technology, system design, and other factors? So this is where we are also at the moment in our own research, raising these questions and see how we can take this forward. And Cynthia is going to comment a little bit more on our view on what is the potential for mitigation here.
Thank you, Sabine. Very happy to be here. Yeah, so I have the task of trying to put a somewhat different face on this and consider ways in which, if VRI is coming along as it is in Europe, we don't really discuss too much any longer if this is going to be a reality in our situations or not. So we need to look at the ways that we can make this work as well as possible. And we start out by saying that no system is 100% fail-safe. There is nothing that is perfect. There are going to be some problems, and there are going to be some situations in which VRI might be a productive component of a general interpreting services program, and some situations in which it would not be appropriate to be used. And we start out, Sabine and I are academics, we do research, we observe things, we try to study things from a neutral point of view. And the best way, we think, to solve any of the problems related to this issue is by really trying to identify the components, the variables that exist. The information that Ms. Sabine just gave is an example of that, trying to define and design research studies that will really help us to understand what works and not. There's an interesting fact that Sabine presented this morning in the workshop, and it said that similar studies to the one that they tried, that was carried out through Avidicus with the results that she just reported, similar study was done with conference interpreters, for example, who started to use video conferencing, and they didn't find the same sorts of results. They didn't find a significant increase in error production or problems and that sort of thing. And that is another question mark for us. Why is that the case in conference interpreting and it isn't the case over here? And we could certainly address that, and we have some ideas ourselves. But what I'm going to see is that if that's the case, I think that there are some ways that I think we can at least aspire to a situation in which, if and when VRI does become a reality, we can ensure the quality of the work that we provide the judicial system. So we need to look at components, variables, study them carefully, do independent research. That means, you know, with independent researchers who don't have a vested interest in one point of view or another. The results need to be shared, and that's why we think this is particularly interesting for those of us on the other side of the pond to be able to hear what your situation is and what your concerns are and what results you're finding. And of course, collaboration and cooperation in the entire field. I'm going to try to very briefly, in a bulleted fashion, address issues related to technology, things that we have to keep in mind to mitigate the problems from a technological point of view, from the point of view of the interpreter, from the point of view of jurists, in other words, what can attorneys and judges contribute, and very specifically towards the end, because I happen to think it's the most important point, from a policy point of view, institutional support, what kinds of policies are put out by judicial authorities. So from a technical point of view, I think we'd all agree. I mean, the first thing that we have to be concerned about is high quality equipment. We have to have a good set of equipment designed specifically and adapted to the needs of interpreting, not just video conferencing, which is done in courts in the same language situations, but we have to take into consideration what language mediation means in those situations. As Sabine mentioned, and I'll mention it very quickly, there has to be correct deployment or placement of the equipment based on a sound and rigorous analysis of the interpreter's needs and also of the needs of the court, of the judges, of the witnesses, and everyone who's involved. There should be structured usage protocols developed, and these should include steps for continual maintenance and testing of the technology. Should be pre-session tests almost on a daily basis. If we're going to be using the system on a daily basis, the day needs to start out with the technicians testing the system so that we don't have unexpected problems during the day, and any issues that might exist can be hopefully identified and dealt with. And then the whole issue of technical support and technicians needs to be dealt with. We need to have people at all points where the system is set up, where the system is being used. If we have a connection between prison and a remote interpreter and a court system or something like that, something can go wrong at each of these points, even if it's with the microphone or with an earphone or whatever, and we need to have some way, some protocol set up. These are all things that have to be addressed. And I think whenever you deal with a vendor, whoever the vendor may be, if you do purchase equipment and technology, I think the issue of maintenance and technical support needs to be addressed very seriously, and it needs to be included in the contract. There need to be contractual stipulations about, if I buy your product and I need service, I need it now, our system cannot be waiting, and that needs to be written in. We deal with this at universities all the time with our laboratories, but of course if our laboratories break down at the university, you don't have class for a day or two. The consequences aren't exactly the same as if your judicial system, if cases need to be rescheduled, people are there, arrangements have been made, and then there's a glitch that can't be fixed. So I think that needs to be built into the contracts. And then, of course, backup strategies have to be contemplated, and they have to be included in the protocols, and they have to say, if this happens, this is how we're going to handle the situation. All of these things need to be thought through. The interpreters that are used need to be experienced. They need to be certified, of course. It's very good for me to hear that here in California you use only certified interpreters. They have to be expected to manage additional stress, and the only way that this can be done is through additional training. If training and education isn't included in the mix, I don't think it's realistic. The training needs to include practice sessions, simulations, not just an explanation of, not just what we're doing today, which is identifying what the problems are. Training needs to be real, it needs to be practical, it needs to be simulated, and all the participants need to be involved. And it needs to be fairly extensive, not a weekend course. You know, we don't develop the skills that we need for specific things without really giving it the attention that it needs. Interpreters that work with VRI have to have excellent communication management skills, and I think they really need to have a proactive attitude. I think any interpreter who works with VRI has to feel very comfortable with speaking up when something's going wrong, when something doesn't work. And that doesn't have to be a technical issue. That can be any issue that they find that I find that this isn't an effective way of carrying out my functions. As regards judges and attorneys, jurists have to really be made aware, and we've talked about this so much today. Jurists really have to be aware of what interpreting really means, what it really entails. And I'm not saying that just to say it, because we all say that all the time. They need to know this, they need to do this. You know what? They really need to know this. And until judges, I just gave a course in Spain to a bunch of judges, and they were surprised. And every person I talked to who has had a significant conversation with judges says the same thing. Oh, they didn't realize, you know. So that needs to take place. I think judges in the courtroom have to give clear instructions to everyone when VRI is being used about what the peculiarities are, how they need to speak, how they need to moderate the pace of their turns, the volume, that there must be respect for turn taking, that they can't interrupt one another. We saw our lovely vice presidential candidates the other night. And without naming names, if we put them together, we have over 100 interruptions in a 90-minute session. And that's not counting the moderator. And we all came away from that going, that was very ineffective communication. So those kinds of instructions need to be given by the judges. And attorneys need to take into account as well how they need to modulate their questioning styles and their voice and their speaking styles to accommodate. Very quickly, policymakers and judicial authorities, we're very glad to have some with us today. I think there needs to be a recognition of the potential benefits, but also of the limitations of VRI. All factors must be considered without the focus being exclusively, as Sabine said, on economic considerations or expediency, although we know that those are important factors, and if we want to ignore that, we're not doing ourselves any favors. Representatives of the interpreting community must be involved at every stage of development. If you do not involve them, you're not going to have a successful program. You don't know what their needs are. Who else is going to tell you? So I think that's basic. All stakeholders should be brought together to collaborate through the development stages, the piloting. It's very important that adequate funding be given not only for the technical aspects, but for the human resources aspects. You need to take into consideration those kinds of things. And I think you should require education and training for everyone as part of these language access plans. Write it in, write it in. I'm done. I've got really 30 seconds left. I think it's important that we approach VRI with an open mind. I would ask you to, because I think technology is here to stay, we need to approach it with an open mind, a responsible point of view, recognize that it has the potential for contributing to the solution of some kind of prickly problems, but that it's not a general panacea, it's not going to replace human expertise or human interaction, but that if we collaborate to find the limits of VRI, when it's best suited, what kinds of proceedings it should be used in, which ones it shouldn't be used in, we could be successful. With new systems comes, new possibilities, and the possibilities can either go north or south. So good luck. The best that I can say is good luck, and I think Sabine and I are more than willing to consult on any aspects if need be in the future. Thank you.
So just for everyone to know, we have the cards passing around, so please feel free to write down some questions for us and pass them to our monitors. And now we have Professor Eagly, who's going to talk a little bit more about the impacts of video hearings in court in terms of participation and engagement of the parties.
Great, thank you so much. It's such an honor to be here and really looking forward to sharing with you some of my research findings regarding the use of video conferencing in immigration courts. How many of you interpret in immigration courts? Okay, so quite a number of you will be familiar with what I'm talking about, but the use of video in immigration courts isn't that dissimilar to how video is increasingly being used in criminal and civil courts all around the country. The research that I'm presenting is based on data that I analyzed based on FOIA requests, public records requests to the immigration courts, obtaining actual recordings of all of their data in terms of how cases were adjudicated. So it was interesting to be able to actually have a real natural experiment of the rollout of video conferencing and how it impacted individual cases. So I think that most of you are familiar with the basic concept of video adjudication. It's often referred to in the immigration court context as televideo or video conferencing. You all are using the VRI term. So here we have an example of a respondent in immigration court. He's at the McHenry County Jail in Illinois, and he is being beamed into immigration court in Chicago. The judge is sitting remotely in Chicago, as is the interpreter, the prosecutor, and his counsel. So here's another example. This is a picture of the downtown immigration court in Chicago, where I visited doing this research. I went to 12 different hearing locations around the country to observe these court hearings. At this Chicago location, you have respondents who are being held at a number of different jails and prisons, and from those locations are being beamed into the downtown immigration court. Pictured on the left is the Kenosha Detention Center, which is part of the Kenosha County Jail in Wisconsin. And they have their hearings held in downtown Chicago by video conferencing. This is a photograph of an immigration court. They wouldn't let me actually take photographs inside the court, but I got this photograph from a public records request, and you can see the basic setup. It's not unlike other courts. The judge has a monitor at his or her bench, and on that monitor, the judge can see the respondent or the interpreter, whatever party to the litigation is remote. And there's also a larger television, which is generally facing the litigants, the prosecutor, and at sometimes the defense attorney. There's not always an attorney in immigration court. There's no right to an attorney. And on that larger screen, whoever is at the remote location is beamed into the central court where the judge is sitting. I know you're all interested in where the interpreters are. I saw a lot of different setups for the interpreter location. The most frequent was the interpreter being co-located with the judge. Sometimes the interpreters were located remotely in the prison or jail with the respondent, and other times the interpreter was located in a third location, requiring there to be two different video feeds, or sometimes a telephone feed and a video feed. So when did immigration courts start using televideo? They started using it in 1996 as a pilot program in Chicago. Once that pilot program was completed, they rolled it out all around the country, and they're now using it in detained courts all throughout the United States. At the time of the data that I analyzed, which was completed cases from 2011 and 2012, almost 1/3 of all detained cases were adjudicated entirely by video. I found that once video was used for the initial hearings, it was also used for the trial, so it provided, and people were randomly assigned to either video or in-person adjudication, so it provided a natural experiment to sort of look at these outcomes. My study's quite long and we don't have much time, but I just want to give you the simple picture of what was happening in terms of outcomes across televideo and in-person cases. So I think there's a number of important measures. One is whether an immigrant obtains an attorney. There's no right to an attorney, but you can obtain an attorney through a nonprofit organization, or you can hire one. Another is whether you actually apply for relief. This could include applying for asylum or cancellation of removal or adjustment based on a relative such as who might be a U.S. citizen. And also whether an immigrant decides to apply for voluntary departure. And on every single one of these measures, immigrants who had their hearings held over video conferencing were less likely, statistically significantly less likely to obtain representation, apply for relief, or apply for voluntary departure. And in the paper, I include a much longer analysis, which includes a regression analysis, controlling for both respondent and case characteristics, and the patterns are consistently the same. In other words, immigrants are less likely to engage in their cases when their cases are held over video conferencing. So in my qualitative research, I set out to try to understand why would this observed litigant disengagement be occurring in the video setting. So what did I find? I found, first of all, that there was, and I interviewed judges and immigration attorneys throughout the country. First, I found that there was a disruption of the litigants' interactions with other courtroom actors. So for example, attorneys repeatedly described their dislike of the video proceeding as something that was really rooted in the disruption of the relationship between the attorney and her client. As one attorney in Chicago told me, "Why do I hate it? Because if I need to take a recess with my client remains on the screen. You hear right through the walls. The judge just goes back in chambers. The judge hears everything you say. There is no confidentiality to break with your client who is on a screen." Another group that I interviewed were volunteers. Some of these courts had volunteers who were doing court watch programs in these immigration courts, which tend to be fairly remote and don't have a lot of participant engagement. One of those volunteers, who was actually a full-time librarian, explained to me, "I feel it's unfortunate that they can't see their lawyers." And here she's referring to the camera angle, which was varied at each location, but in every location, in all 12 of these hearing locations that I went to, there was always a decision that had to be made in terms of who could be on the screen. You could never see the entire, from the remote location, you could never see all courtroom participants. All they see is the judge and the interpreter in front of them. And I think that's very important to see the lawyer for body language and reinforcement, encouragement. They don't get that. They hear their lawyer and that's all. And I think that's a real difficult problem. That is something that's missing. Another aspect of this disruption that's caused by the video screen is in the interaction with the judge. Attorney after attorney explained just how difficult it was for the respondent to understand what was happening. This attorney explained the person who's on the screen and the judge just never would address the respondent, and to the point where he would ask the respondent questions and just not look up when the respondent would talk. And I have always thought that's at least partially related to the fact that the respondent isn't in the room. And this is something that I observed directly as well, that as someone was on the video screen and remained on the video screen, they weren't really participating in the process, and the interaction, not only was it not face-to-face, but there wasn't the same gaze of the eye between the judge and the respondent, even when questions were directly put to the respondent. We had the same issue with other courtroom actors, including opposing counsel. Here, one attorney explains that during direct exam and during cross-exam, The televideo respondent hears the respondent's counsel or DHS's counsel asking questions, but cannot see them over the video screen. So that causes a big disconnect, I think, for respondents, especially if it is government counsel and they're making faces, getting upset at the respondents. The video litigants are just depending on hearing a voice. So it just creates a disconnect, I think. Like respondents just can't really feel like they're fully participating in it. The second major finding from these qualitative interviews was that video was repeatedly referred to by judges and respondents' counsel as being something that undermined fundamental dignity, respect, and humanity. This connects to broader research of social scientists such as Tom Tyler and others who have found that regardless of the actual outcomes of proceedings, if participants perceive a proceeding to be unfair, they're less likely to participate in it, and they're less likely to obey the outcomes that come from that process. So one attorney that worked in Texas in a remote detained location explained to me, none of the people detained there like televideo hearings. They say that they feel like their due process rights are being violated, that they're not getting a full, fair hearing. I mean, even the ones who win, how is it fair? Here's a quote from an immigration judge who I interviewed in San Antonio. And for me, I guess the main thing is the humanity thing. It really is like television. And then when the show is over, you turn it off and go on your way. So to me, it's kind of dehumanizing. That's my main concern about it. So just to conclude, I think that this research highlights something that doesn't tend to be discussed in the context of remote adjudication. We tend to hear the kinds of arguments that remote adjudication helps safety, makes hearings go faster, doesn't affect actual outcomes at trial. But we don't tend to hear about what it might do to respondent engagement in the process. What I've found is that video litigants are less likely to find attorneys, they're less likely to seek relief, and they're less likely to engage in their own cases. So I think we need more research about video and its engagement effects, and whether, particularly for purposes of this audience, whether interpreters suffer from those same effects. Surely technical difficulties, being unable to comprehend as effectively without the full visual cues and participation of the other courtroom actors. And perhaps it could be perceived by interpreters as being dehumanizing, as not being a full part of the process, not participating within the courtroom with all of the other courtroom actors. This could result in fatigue and burnout, as other studies have found. So I think we need more research, and I think that research should not just be looking concretely at outcomes, speed, and safety, but also should be thinking about engagement and legitimacy of our court process.
Okay, if everyone could please remember to, if you have questions written down, get them to our monitors, because we're about to come up to the Q&A time of our presentation. And here is Mary Lou Aranguren to kind of wrap it all up and put it in context of the political context, California today. Mary Lou.
Thank you. Hello. This is always uncomfortable for me, so let me know if you can't hear me. So what I'm going to try to do, and we've all had very limited time to cover sort of broad information, is to give you an overview of the issues that CFI has identified here in California with the effort to implement VRI, and also what our recommendations and goals are to address these issues. I'd like to start just giving you a little information about what we've been doing. We have been following the LAP process that Janet talked a little bit about and has been involved with. CFI is not included in the LAP working group, in the task force. We believe, and we have repeatedly said, that as the representative of a very large number of interpreters in California, we should be there. But at this point, we are outsiders who have to observe the process, try to follow it with all these different subcommittees and all the different activities going on. And we have submitted extensive comments with our recommendations, but we're not part of the conversation or the dialogue. It should also be noted that there are only 3 interpreters on the task force out of probably 15 or 20, plus many staff people supporting the task force. So we're a very small minority in terms of the stakeholder participation. And that's one of our concerns that we have voiced, but there has not been a satisfactory response from the Judicial Council. Research also on this topic, as you've heard, is relatively limited. We have some fantastic information here from some of the foremost researchers in this area. There's not a whole lot more. And our concern is that that research is really not part of the serious discussion in the policy-making arena for implementing VRI in California. We have also looked and traveled and gone to see what's going on with VRI in Europe, in other parts of the country, to see how is this being rolled out elsewhere, how is it working. And a sort of primary issue that I think you all can sort of surmise from what you're hearing is that VRI is coming down the pike, and it's being implemented in many different ways, in many different settings, in a way that we believe is putting the cart before the horse, before adequate understanding of how it impacts interpreting, how it impacts due process and civil rights. It's happening anyway. So we have to deal with that reality, and we will deal with that reality. Some of it will be by identifying ways to adapt interpreting and make it work better and using VRI. Some of it will be in trying to restrict VRI and get policies made that recognize its limitations. In addition to there not being enough stakeholder participation that we believe is really meaningful, that they're not paying attention to the research, there are inadequate text standards. We've seen that kind of play out in 2 ways here in California and elsewhere. First of all, we have places like Fresno in the Central Valley where they've tried to use incredibly, I'm trying to think of something polite to say, incredibly inadequate system that really simply doesn't work. But it's been rolled out, and the Judicial Council has accepted that, rather than saying we should wait until we have text standards and minimum standards that are acceptable. They have said, we're going to create text standards, but we're going to let anybody else experiment in any way they want. And we were very much against that, but that is what's happening. The reality is that the system is so atrocious in Fresno that it doesn't work and they're not using it. So that's the upside of that story. But we've also seen that there's been a trend to look at high-level, high-quality technology in the piloting of VRI. And so the RFP for California, for example, says that they want people to give them the equipment free to use during the pilot. So if there's a very high-quality system, they're not obligated, however, to use it after the pilot or to buy it. So what happened in Florida, and we've documented this in some of our comments that are available on our website, is that one of the interpreters there said, they let us test drive the Cadillac, and then they bought the Chevette. So, this is a problem, and they're replicating that problem in California by saying, we don't have to buy the equipment, we'll use it for the pilot. Another thing that we've seen is that, and we've done an extensive amount of study, including getting Freedom of Information Act information from the Judicial Council to look at what they did with American Sign Language. They did pilot and implement ASL VRI in California. And we did a very, very exhaustive review of that. And what we found, which is very concerning, is that basically, the Judicial Council created this pilot program. They adopted what we think are pretty good guidelines for that program and pretty good text standards. But then when they rolled it out, it just they didn't follow the guidelines. The guidelines were not mandatory. So when it was implemented, they used independent contractor interpreters, some of them working from home, who invested their own money in the equipment. And then everybody wanted to see it work, including the Judicial Council. There was no independent review or evaluation. And they promoted the ASL VRI system as a great success that was expanding access to justice. But when we looked at the facts, when we looked at the real information from the actual evaluations, and we looked at the statistics, we found it was used very little. The guidelines were not followed. There were problems with maintaining certain standards. There was not adequate tech support. There was not adequate training of all the participants. So some of the things that you've heard people talking about that need to happen for it to be used correctly were not being done. And yet, the Judicial Council promoted it as a great success in writing and used it as the foundation for expanding into spoken language VRI. So these are the things that cause us great concern about whether implementing VRI here in California will be done correctly. We published a paper about this, and it's on our website. I encourage you all to read it because it covers a lot of the same issues and topics that we're talking about here today. Finally, I want to say that in our collective bargaining, we have this interesting contradiction that Janet mentioned, that we have an LAP plan that says in-person interpreting is preferred and will be the priority. But in collective bargaining, the courts are refusing to spend money that they have to improve interpreter jobs and compensation in a way that will ensure that we can use in-person interpreters whenever possible. That combined with the focus and attention and energy that's going into VRI, I think causes us really real concerns. Very quickly, in terms of our recommendations, and what we intend to advocate for. We want there to be mandatory guidelines and restrictions on the use of VRI. As was mentioned, we need protocols, we need clarity, there needs to be training. That can't just be an idea. It can't be something on a guideline or checklist. It needs to be something that's actually done. It costs money and resources and time and effort, and it's not, and so we're going to be pushing for those things to be mandatory. There needs to be a legislative foundation for setting these terms for how VRI can and cannot be used. And because the Judicial Council and the courts as policymakers have shown that they are not willing to do it correctly. And that's their track record. We'd be very happy to see that change. We'd be very happy to see a more collaborative approach, but we believe that the legislature needs to set some guidelines. And finally, I just want to say in closing that California is the first place anywhere in the world that I'm aware of that there is a very large workforce of interpreters. And we are organized and we are represented. And it is really going to be up to us because we do care not only about our work and our profession, but we care about the services we provide and the people who use those services, including the court system. And so it's going to be incumbent on us to hold the line, to work together collaboratively and in an organized fashion, whether we're independent contractors or employees, to see to it that this is not a runaway train where VRI is used inappropriately. And we do believe that VRI can be used appropriately. There are many settings where it can be used for interviews and for situations where currently there is not access. And we should be providing that access, but we're also concerned that they're not interested in that because it's mostly outside of judicial proceedings. So finally, included in those guidelines is not just protocols and tech standards, but it's also clearly restricting those things that are appropriate for VRI to simple and non-complex proceedings. And can I take 25 seconds more?
5 seconds.
Our advocacy has been pretty active in Sacramento, which I hadn't mentioned yet. And we've spent a lot of time and energy, our comments to the LAP, and all of that also goes to the legislature. And recently, there was a positive development, in our opinion, that is resulting not directly from our asking for it, but from people being more aware of these concerns, is that the interpreter budget has been restricted with the following language. Interpreter services shall be provided by in-person interpreters. After all reasonable options for an in-person interpreter have been exhausted, a court may utilize other approved means to provide interpreter services from a certified or registered interpreter until an in-person interpreter is available. Let's keep going.
So a round of applause for all our wonderful panelists. I hope that was enjoyable. It looks like our monitors are still going through sorting the questions that we've gotten coming in. So I'm going to go ahead and start out with a couple of questions, and then we'll start up with the questions from the audience. And like I said, afterwards, time permitting, also just by a show of hands. Okay. Okay. I guess my first question then would be for the researchers from Leviticus. In California, it looks so far like what's being considered is a system of VRI that is capable of providing simultaneous interpretation, not just consecutive, by interpreters located at a third location, remote from all other parties, and also for on-the-record courtroom proceedings. How is that different from what you have seen and studied in Europe? And do you have any comments with regards to the potential impacts of this kind of a system and its viability for application in the courtroom?
Yeah, okay. This system that, well, from what we understand, is planned here, we have so far only seen that here in the United States, in Florida, for example. Yeah. In the research that we've done in Europe, there is, in the Canaries there is, but not simultaneous.
No, not simultaneous.
No, not simultaneous. So in Europe, first of all, it is at the moment, in all the instances where video conferencing and interpreting are coming together, the more common setting is the setting that Ingrid, in fact, described, where the interpreter is part of a video conferenced hearing and is on one of the two sides, and only in very rare cases, by the way, on a third side. So the situation that we have, that you are looking at here, where the interpreter is remote and everybody else is in the same place. In a legal setting, the most systematic case is the Metropolitan Police in London, what I explained earlier. They introduced that several years ago, but they don't do simultaneous interpreting, which is mostly, I think, due to the nature of the police interviews. They are traditionally, of course, interpreted consecutively, so the Metropolitan Police has made no effort to even consider simultaneous interpreting. Remote simultaneous interpreting is otherwise only used in international institutions, in the European institutions, in the United Nations, although only occasionally. The AIC, the International Association of Conference Interpreters, has opposed that use of video conference remote interpreting. They think it's not a proper use of the technology. That's their opinion. What I find when I look at this solution that has been proposed here, which, if I understand it correctly, is a combination of consecutive and simultaneous interpreting, the potential benefit of it would, of course, be that it replicates what mostly happens in a courtroom, where you have a combination of consecutive and whispered interpreting, or consecutive and simultaneous through the BDUL, the tour guide system. So that's a potential advantage. On the other hand, as you can see from what I've just tried to explain, in research we have no direct experience with this particular setting. Yeah, and I hope that it has become clear from the other points we've been making. I mean, research is always also contextualized, and the way we interpret is, of course, very situation dependent. So I think this needs to be studied independently, possibly in a similar way that we have tried to approach the scenarios that we have found. And before we can say, is it good or is it bad, we need to study that systematically with a sort of thorough analysis of whether it is feasible, yeah, and going back to the quality, but also an analysis of many of the other points that were mentioned here. How do the people who are going to use this feel about it? What's the impact on a wider case on the justice system? So that would be my answer to that. Do you want to add anything?
I would just mention that we do have one system in Spain, as Sabine says, not using simultaneous, but we do have one situation in Spain that is rather unique. It's in the Canary Islands, and they have taken the approach of having a remote interpreter. They have an interpreter station within their main courtroom, and because they're a series of islands with a lot of smaller jurisdictions and smaller courts and the police and that sort of thing, and because there's a very significant immigration problem there, or situation, I don't know if problem is the correct word, but a lot of people come by boat and float over, and they come with a wide variety of languages that we do not have interpreters for. And so they have identified, because on the Canary Islands they do have these communities, and they have identified people with whom they work to train and to orient to what they need to do. I wouldn't say they're at the certified level, at the certification level, but they do their best in specific situations, and they have found that being able to use the people that they've identified gives them a greater sense of security in terms of the quality, and they can share that with other venues, you know, where they need some of the same services. It's the only one I'm aware of, but not for simultaneous and at all that I know of.
Maybe one quick comment. We do have anecdotal evidence from interpreters who do interpreting in court where a defendant, for example, is somewhere else, and where therefore what they normally do, whispered interpreting, is not possible. That they find the situation very unusual and peculiar, and it takes a lot of adjusting to it. And also we have comments from interviews with judges who, for example, who say they don't particularly like this, because then of course the proceedings take longer. So there is that feeling of objecting to not being able to do simultaneous. So in that sense, again, I think that might be a potential benefit, yeah, of being able to have the simultaneous. But from all we know, doing simultaneous interpreting is cognitively very challenging, and it's partially a different kettle of fish. Yeah.
In our server, we have several interpreters.
Yeah, some of them have said it. Yeah.
They would like to be able to technologically be able to. We had a certain percentage of interpreters who felt comfortable with simultaneous and said they would like to be able to provide that. So.
Yes, that's right. But then we also had situations where in countries it had been decided, for example, not to go that way at all, because they were not sure whether they have the interpreter pool ready for all the language combinations that they need to actually provide simultaneous interpreting in that consistent way. So that's there are other issues that are also linked to that have to be looked at. So that was a rather long answer, but I mean that the point here really is there isn't a shortcut to saying yes, this could be good, or this is it needs to be looked at. It needs to be looked at in terms of a pilot that does exactly that.
Okay, I'm going to do one more prepared question, and then we're going to go with the questions from the audience. And this one is actually for Mary Lou. It looks like the Judicial Council has been prioritizing this whole VRI project pilot project, but until now we haven't seen a pilot project to see what it would take to actually provide interpreters, in-person interpreters, in a comprehensive manner, in a holistic manner for on and off the record communications that are high stakes communications that become evidence or recommendations to the courts and other kinds of things where really the best would be to have in-person court-certified interpreters. So I was hoping that Mary Lou might talk briefly about what would be a better approach. The LAP itself recognizes throughout that in-person is preferable for many of the same reasons that Professor Eagly has mentioned, for example. But we're not seeing the prioritization of providing comprehensive in-person interpreters as part of the expansion to civil and so forth. We're seeing more of a narrowing of the scope of our work. And then we have this pilot project for VRI, but none to show, okay, let's do a cost-benefit analysis here. What would it take to do something in person? So I was hoping that, I may have answered part of that question, but I was hoping that Mary Lou could address that a bit.
Well, I mean, I think that we've made numerous recommendations that haven't been followed. So, but one of them was that they actually pick a couple of pilot counties and that they pilot providing across-the-board interpreter services in person in those counties. Maybe pick a small county, a medium county, and a large county, and then evaluate what the cost of that was as part of the cost-benefit analysis. And then if you're piloting VRI in these other counties, you could see what did it cost to do VRI, what did it cost to do the equipment, what did it cost to do the training, what did it cost to get the equipment handlers and the technical support in place, and then do a comparison. And I do think that California is very unique in that we have this very large workforce of interpreters. So it is not the norm that in-person interpreters are not available. So we're not clear about why there's the push for VRI. We recognize that sometimes in, Timbuktu County in Northern California or somewhere, out in the great, east of Riverside, there might be a need for an interpreter in an exotic language where it might take a couple of days to get somebody there and it'd be better to have an arraignment over VRI. But we don't understand the push for not sort of seeing how much can be done with in-person interpreters. And one of our biggest concerns that I didn't mention, and you sort of alluded to it in your question, is that VRI inherently limits access in the sense that the moment that the headphones are off or the screen is off, the interpreter is gone. And we feel that that's something that hasn't been looked at all. The promotion of VRI is that it will expand access to justice for LEP people, but the qualitative aspect of access, how broad is it, what's the scope of work we're doing, that combined with efforts that we're seeing in Los Angeles and other places to narrow the scope of our services, right, with attorney interviews, probation interviews, and other things, it gives us a sense that what the LAP says about prioritizing interpreter services, in-person services, and about expanding access is contrary to the policy decisions and direction that we see things going. And that's why, and one other thing is that, whether we can do some of what needs to be done through collective bargaining is something that's of great concern to us. We think there needs to be good policies through the legislature and the Judicial Council, hopefully, that make things mandatory and clear, because collective bargaining is inherently a process of give and take and negotiation and compromise. And we don't believe that the type of access that people get and the level of access that people get should be subject to this kind of compromise. It should be more a matter of collaboration, figuring out how to get it right, and setting good policy. And so we're very concerned about that, and already we're facing this issue in collective bargaining, and we can bargain over things like, rotations and turns on VRI and how long you have to do it. We can even bargain money for it. And I want to propose to you that there's going to be many challenges and conflicts for us in this. And that's why we want interpreters to be very well educated about the implications, because they will throw money at us to do VRI. And if we start competing to get an extra $20 or $50 or $100 to do VRI, then we're invested in having it work. And it's fine if it works, But it's not fine if it doesn't really work, but everyone adapts to it and just doesn't worry about the other implications. So there's many, many layers to this, and I have no idea if I answered your question.
Well, it's all good stuff. So I'm going to invite Juan Ramirez up here to start. It sounds like all of you have a lot of great questions. So what Juan did actually was to kind of collect some of the ones that seemed very similar, synthesize them, and he's going to go ahead and present those questions to our panelists now. Thank you.
Thanks, everyone. Thanks to the panelists, and thanks, everybody, for your questions. We had a great number of questions. Some are very simple, and I'll start with some of the more basic ones. This sounds like a question for Janet regarding the pilot, if you have an idea how long it is to be in effect.
The pilot is supposed to last about 6 months. It's going to start this January 1st in 2017, and it's going to be implemented in those 3 counties. I don't know if the pilot will be extended or not, but it's just planned for 6 months.
And then a number of legal questions. I'll start with one that sounds pretty fundamental. What is the legal justification that deems somebody present even though they're not physically present in the proceedings?
Well, I think that first it was started as a pilot program, and in the pilot program you had to consent to participate in it, but then in the immigration court context, Congress passed a new law that said that it was mandatory, and that if you're assigned to video, you don't have the ability to object to it. You could object to it, but people have tried, but all of those motions to be moved out of video conferencing by Respondents' Council have been pretty uniformly denied, such that attorneys that I interviewed no longer bring those motions. But I think the justification, the rationale behind those sorts of laws as mandatory assignment to video is really this idea that video is sort of a neutral tool, right? That outcomes don't vary based on video. That's the assumption behind it, that we're getting the exact kind of communication over a remote medium as we are getting in person. And I think that's why these sorts of pilot programs and research around it are particularly crucial, because the laws behind it just assume that they're functionally equivalent.
This follow-up to that concept may not be as neutral, but it asks, is there a different standard of fairness being used when language minorities are having to conduct proceedings with a video judge and video lawyering?
Well, that's a very important question. If you are an attorney objecting to the assignment to remote conferencing, one argument that you could make to try to get your client brought out of the remote adjudication is the fact that your client needs an interpreter. So that the fact, if you could really articulate why it is that interpreting over a video makes it even more difficult for you to present your case, maybe it's a particularly complicated case, maybe it involves a lot of documents, those are the kinds of arguments that could potentially be successful in moving out of video. But again, at least in the immigration context, where there tends to be fewer procedural rights than at least in the criminal context, a lot of these motions have not been successful.
And for Professor Eagly, just so you know, some people are requesting electronic copies, and they want to know if there's any of your findings that are available electronically, if those could be shared. A more general question to anyone on the panel is regarding attorney-client confidentiality. Is anything being considered to safeguard attorney-client confidentiality in these communications?
Yeah, so the attorney-client confidentiality issue is a huge issue. Generally, what the procedure has been in the courts that I've observed is the judge will clear the courtroom, the judge will leave, the prosecutor will leave. The attorney that I shared the quote from was concerned about people even being able to hear in other rooms, just sort of the perception of fairness with the client. How can I have my client on that gigantic screen I showed you the picture of, and even pretend that this is confidential? And then there's also the concern, the client is, of course, at a remote location in a prison or jail, and I attended a lot of proceedings at the remote location with the respondent. In many of the locations, I was the only person, I think, from the outside who'd ever actually insisted on that was a courtroom, and I really wanted to sit there and watch from that end. And the prison guards are always present, so that's a separate issue. If you could actually convince remotely, or if you would even know that whether a guard had actually left that room. So confidentiality is a huge issue, and one that I think is very, very difficult to resolve. In practice, attorneys tend to be doing fewer meetings with their clients, and fewer sort of sidebars. If you were in a courtroom, you would be talking to your client as they're sitting next to you, explaining what's happening in the proceeding with the assistance of an interpreter, apart from what's going on the record, so to speak. So I think all of that is something that's missing when we're removing people from courtrooms.
And this has come up in the ASL-VRI thing that's in our paper. What we found was that attorneys complained that they didn't have a systematic way to communicate with their clients privately, even though the guidelines provided for that had to be part of the setup. It's just that the guidelines, as I said, weren't followed. People didn't understand how things were supposed to work. Judges were unaware, and when the judges did the evaluations, they said that they didn't know whether or not there needed to be confidential communications or how the system was set up to provide that. The attorneys said they didn't know and didn't have the opportunity. So, these are the realities, and then, of course, the fact is the Fresno system had a thing where if the attorney wanted to talk to his client, everyone in the courtroom had to remove their headsets except the attorney and his client. And then someone had to turn those off so they wouldn't hear what was being said. So it was a complete artificial interruption of the proceedings that they thought would work just fine, right? So then that means that the client has to say, I need to talk to you. The lawyer needs to say, stop everything. The judge has to say, take off your headsets, everyone. They're going to have a conversation. So how conducive is that, right, to those communications happening? And I think that one of the things that people are not thinking about with VRI is how the physical logistics of the equipment and the stopping and starting and the access are unavoidably limited, right?
I would actually add a little bit, but I'm glad you brought up the whole thing about ASL VRI. Just in the interest of fairness, there were only about 6 evaluation forms even received from judges for that pilot program, so I don't know how statistically relevant that is, but at the same time, half of them said that they had not made provisions for confidential communications, and the other half said that they didn't even know. They also got just 6 from attorneys, and they all said, every single last one of them said that it had not. But another thing that's been talked about is sort of the encumbrance of having to get access to the equipment. So even if it's not like a case like in Fresno where everybody else in the courtroom has to take off their headsets, let's say you have a cart where you send a cart somewhere with the equipment so that you can link into the interpreter or whatever the setup might be. It's an encumbrance. You have to have somebody to either take the equipment over to where it is, if it's available. Maybe they already took it to another courtroom, or you have to take extra steps to make it happen. So it's not the same kind of access when somebody's in person at your elbow and just talk. right? And so what happens is that those conversations don't happen. The other point I want to make about this is, one of the rationales that's given around VRI is that people don't want to wait for interpreters. Well, I mean, a little bit better coordinating might help with that problem. It wouldn't cost as much and would allow us to do stuff in person. But beyond that, if you don't want to wait for an interpreter, do you want to wait for the equipment handler now, with this cart to go take it over to wherever you are so that you can talk to your client? So some of this stuff just isn't really at the forefront of the planners' thought processes here, and it really needs to be.
In terms of the physical setup of some of the programs, is there any allowance made for a defendant, say, to be able to see audience members or to see if their family members are present in the audience?
I'm happy to address that as well. I think the courtroom audience is a really important point, so I'm glad that you brought this up. It's something that I do discuss in my paper, which is available online, so any of you can have access to it. The original pilot in Chicago had 2 large televideo prompters. One, just like in the picture that I shared with you, one was facing the litigants, so the prosecutor, the defense attorney, and the judge, and the other was facing the audience, so that the audience could observe what was happening at the remote location and see their loved one on that screen. However, when they rolled out televideo nationally, they removed the second video screen from every courtroom in the country. So this has caused a lot of the interviewers that I talked to talk about this problem of the lack of engagement of the courtroom audience in the process, that they can come from very long distances to see their loved one in a removal proceeding, perhaps the last time that they will see them before they are banished from this country, and they're not actually able to see their loved one. They're not actually to communicate with them. They're not actually able to talk with them. Occasionally, judges at the very end of the proceeding would say to the respondent after they'd already ordered them deported, "Oh, by the way, your mother was here," or something like that, right? So if you think about it from the respondent's end, when I would see those things on the respondent's end, they're there going through their hearing not actually knowing if their loved one came to that hearing. And again, this goes to, it might not necessarily affect outcomes, but I think it's something that matters in terms of the legitimacy and the dignity that our court process provides.
Yeah. I could comment on that from the point of view of visibility in general. With what we have found in the latest part of our project, where we surveyed 12 countries of the European. Sorry, yeah. There we go. In the latest part of our research, where we've looked at sort of 12 countries in the European Commission, how they do different types of video links, we have noticed that there's a lot of variation between what is actually visible or what is made visible on screen in the courtroom, in the remote location, so there's no common standard, and what is well, we have of course looked in particular at whether the interpreter is being made visible or not, so that varies as well. Also the attitudes towards whether the interpreter needs to be seen or doesn't need to be seen, they vary both among judges and interpreters, by the way. What I also find noticeable and concerning is that some of the informants that we asked didn't actually know what the other side can see. So often the judges in courtroom, they said, well, I don't know whether they see only me or whether they see the whole courtroom or what exactly they're going to see. And judges also sometimes couldn't remember what they had seen from the other side. We asked for some, did you see the interpreter on the other side? When an interpreter was like in your situation, when an interpreter was placed in jail together with the defendant, and they couldn't remember whether they actually only saw the defendant or whether they saw the interpreter. So there are, I think, a lot of issues around visibility that need to be put on the agenda. I mean, and if you have a video link, I think the most normal assumption is that you think there is mutual visibility. So I think we all tick that way. We think, but if I can be seen, I assume they see me as well. So if that is out of kilter, of course, you have potentially implications also on the communication. So if I talk to you and I assume you all see me, I will use gestures, I will use facial expressions, and if I come to realize that it's actually more like talking on the telephone to you, I would adapt my behavior, but that assumes that I know what is going to happen. So we did find that as well, and of course, as you say, we don't know yet whether that has an outcome as such on the proceedings, but I think we have mentioned a lot of points here. This is one. If you take them all as contributing factors, you do begin to wonder how all these factors taken together might potentially alter the communication. So that's what concerns me about this as well.
And if I may add one more practical aspect, the handling of documents, whether it be the signing of documents or any other physical documents, does that present a particular problem?
In our studies, it definitely did. It was a comment that was made very many times. In some courtrooms, there were document readers and document carts that they could put up on the screen, but many times there weren't, and it was a comment that some of the attorneys mentioned that was a factor that needed to be addressed more. So evidently, that is not taken care of.
And the ASL for VRI system, that was one of the issues that the interpreters raised, is that they didn't have access to documents ahead of time to prepare, even though that was, again, part of the guidelines, part of something that was supposed to be available, it wasn't in fact available. And they also had times when, the whole thing got stopped and continued because nobody had thought about the fact that there was no way to share documents, or they would hold the documents up to the screen and try to, get them to read them. So there was supposed to be a system in place, but it wasn't working, and that, and then I wanted to just mention on the previous point that in the Fresno situation, we raised the issue of whether there was a camera on the courtroom or a screen, I think, in the courtroom, so that people in the courtroom could see what was happening in the remote location, or some version of that, and I apologize, I don't remember the details, but they asked us why, and we said because courtroom proceedings are supposed to be public. And it was sort of lost on them, even though that these were judges and lawyers that we were discussing this with in negotiations. So there's a tendency to just think that if you have audio and video, right, that that's it. That's all you need. And of course, the research that these folks are doing shows that it's quite complex, right, in terms of how it interacts with you. If you really want a virtual courtroom, it's much more complicated.
And just to add to what Mary Lou said, there's currently some counties that are doing video arraignments, URI, and the answer to the previous question is the only thing the defendant, or the only person the defendant sees, is the judge, from what I've been told. And my county is one of the ones that actually does video arraignments. I've talked to other interpreters that have been doing video arraignments. They actually say the same thing. So the defendant really doesn't even see the interpreter, doesn't see his attorney, doesn't see the public defender, the DA, and doesn't see if any of his family members are in the public.
I mean, in those cases, because I'm in Alameda County, and we were doing those in Hayward, and the public defenders over there, from what I understand, asked to stop the practice because, okay, so now maybe they don't have to transport the inmates from jail to the courthouse, but now it's effectively the attorneys have to transport themselves over to the jail if they want to talk to their clients. So people were getting stuck in jail for longer periods of time because the attorneys weren't able to speak with them on site right away, talk to them and then make a good pitch for bail or what have you. So that's another aspect.
Very briefly, post-event, there's often a need to clarify or summarize the proceedings that have just occurred, but I think it was alluded to here that once the screen goes off, language access disappears, or what's your experience?
Yeah, I could could say from observing the hearings, yes, that was a serious problem. There were some judges who were sensitive to this and gave, the attorneys another moment to say something with the interpreter to their clients over the screen. But again, this was in the public courtroom over the large screen, so most attorneys use that opportunity to simply say, I'll come to visit you tomorrow, or I'll be there on Friday. I didn't ever see anything substantive, and oftentimes it appeared over the screen that the respondent was confused and not necessarily even understanding what had happened in that court proceeding, which makes sense because in immigration courts, of course, as many of you know, not everything is interpreted, only things that are directed to the respondent. So the judge's actual decision hadn't been interpreted over the video, adding a whole nother layer of complexity to the understanding outside of the courtroom. In immigration court, only when the judge says to the respondent are words interpreted.
Thank you. And several questions asked about the financial aspect, whether there are any documented savings from the use of VRI that we know of, or someone considers that in fact more interpreters could be needed for VRI because it could be labor intensive.
Should I go for it, or do you want to go for it, Camille? Okay. That is a really good question, and it's a complex question, and I'm afraid we only have like 2 minutes, so I'll try to be brief. But from my perspective as somebody who's been taking a look at this, I think we really need a realistic cost-benefit analysis of this to do VRI right, if there is such a thing. And I think that even when you do it, if you have the best equipment in the world, the best layout, the best setup, all of that, it still has limitations, and it still should not be used for high-stakes courtroom communications, especially hearings, okay? But any high-stake, complicated communications. But if you were to do even just arraignments or basic, simple, two-way, not high-stakes communications, to do it correctly, you still have to spend money. You have to spend some real money, and then you're going to have to maintain the system, and you're going to have to keep regular upgrades, and you're going to have to coordinate between different counties so that they can continue to be connected to each other and all of that. You're going to need some serious infrastructure upgrades to a lot of courthouses, including especially a lot of the older courthouses. That's something that they're not considering when they talk about VRI at the Judicial Council, because they're saying, well, that's part of overall costs, right? But if it's going to actually work and be interconnected, then you're going to have to think about those things. What is the difference between, then is it actually cheaper? Is it actually a cost-effective option to providing in-person interpreters? Is the question, right? The other question, which is a bit of a tangent, but I think is related, is, if you're going to take money and invest in technology instead of investing in good professional jobs, for interpreters, because we all know that our salary has been lagging for a very long time, and we're really behind when it comes to how we're treated as opposed to other court workers. If that's going to keep up, then less and less people are going to go into interpreting. You're going to have less in-person people available, but you're also not going to have people with a level of skills required to actually be able to do VRI well. Because what Leviticus has found over and over again is that it is harder to do interpreting over VRI. And you have to have, higher levels of skills in order to do that work and not have it impact too much the quality of the interpretation. So you're going to have to create good professional jobs, and if you don't do that, then frankly, neither will work well. I don't know if that was a good answer.
Thank you. And I think Cynthia wanted a couple minutes on this question.
Okay. It's When we talk about financial issues or cost saving in VRI, I sometimes try to make a comparison between what is happening there and what we see in learning and teaching, where, I don't know, 10, 15 years ago, there was a big drive towards online learning, online teaching. I mean, we know that from the educational environments where we come from, and part of it was to save money. And I think over the many years that any form of online learning has been implemented, the one thing that has become very, very clear that the thing that it doesn't do is save money. So now I'm thinking what we are looking at here is actually, we are not looking actually at VRI or at interpreting, we are looking at justice. We're looking at quality and fairness of justice. That's still the ultimate goal, actually. Maybe I'm an idealist, but of course, if you have a bilingual proceeding, the quality of justice depends on the quality of interpreting to a large extent. So, I mean, we should use VRI to promote that case. And I think if it is used under this premise, and if it is used in, we were talking about that the other day, in a more kind of a blended approach, where you have in-person interpreting where that is appropriate, you start to use VRI where that is appropriate and where that can actually really achieve an improvement in the justice process and in the fairness and quality of justice, then I think we are on the right track. Which also takes us away from piecemeal thinking. Can we use a little bit of VRI to save a little bit of money here? I don't think that will help us, and in the end, I don't think it will save that money. We need that holistic approach where we blend things together the way they need to be.
Thank you. That's all the time we have.
Thank you so much to all our panelists again, and to all the audience members and everybody who sent up some questions. And hopefully, if you didn't get your question answered, maybe you can catch some of us outside. We can continue the dialogue. Thank you so much.